Good morning, everyone, and a very warm welcome to this ICAS webinar on Scottish charity law reform and regulation. My name is Keith McPherson. I'm the chair of the ICAS Charities panel, and in my day job, an audit partner at Henderson Logie, specialising in the charity and not-for-profit sector. So I have the pleasure of being your host today. So for the first time in a very long time, there are significant changes to Scottish charity law. And these are being implemented in a phased way, starting from April 2024, so earlier on this year, and on to summer 2025. Alongside these changes, there are developments in charity regulation arising from OSCR's updated regulatory priorities and from OSCR's revised annual return. So to guide us through these changes, I'm delighted to be joined today by Gillian Harkness-McKinlay and Martin Tyson. Gillian is a partner at Solicitors Anderson Strathern. She provides corporate and charity law advice to many third sector organisations and is advised on the structure and governance model underlying countless Scottish charities. She is a charity trustee herself of two charities and a member of the Law Society of Scotland's Charity Law Subcommittee, and also sits with me on as a member of the ICAS Charities panel. Turning to Martin, he is Head of Regulation and Improvement at OSCR, leading its main outward-facing functions. This includes overseeing delivery and continuous improvement of OSCR's regulatory casework, as well as its work with the whole charity sector and key stakeholders to build improvement and public confidence in charities. So just before we begin, a few housekeeping matters just to remind you of. As normal for webinars, you can submit questions anonymously if you wish at any time through the Q&A facility, which can be accessed at the top of your screen. We'll save your questions until the end of the webinar for a live Q&A at that point. You can also join into the conversation today through the chat box, also accessed at the top of your screen. And we are, of course, recording the webinar and we'll make it available for on-demand viewing afterwards in case you want to refer back to it. But anyway, I know there's a huge amount to get through today, so I'll pass straight across now to Gillian to get into the detail of today's webinar.
Thank you, Keith, and thanks everyone for coming along to listen to this. Hopefully you can see the slides okay. Yeah, I'm slightly the bitter pill to Martin's nice kind of sugary Calpol syrup. You know, you're getting to hear directly from the regulator, so I'm the slightly disappointing techie bit that comes beforehand. So apologies in advance. Keith's already actually given a little bit of the background to reform, so I will just go through this at jig speed. The Charities and Trustee Investment Scotland Act 2005. My goodness, I feel old because I remember a time before the 2005 Act. I remember being a bouncy, enthusiastic charity law trainee and dealing purely with HMRC charities, not just for charity tax relief as we do now, but for the whole shoot and shebang of getting charitable status in the first place. And when I came back as a newly qualified solicitor, I had to get used to OSCR and the 2005 Act. And OSCR's now had a long time to get used to working with the Act and the benefits of it, but also the limitations of it. And they had made suggestions to the Scottish Government in terms of what they thought would be useful updates to the 2005 Act. And the result was the very catchily named Charities Regulation and Administration Scotland Act 2023. It's really just what I would call an amending act. Its purpose is to amend the 2005 Act, which remains our Bible. And as Keith said, it's coming into force in stages. And the key aim of the reform, of the reforms from the amending legislation, I don't think anyone can argue with these, were to enhance public trust and confidence in the charity sector. So it's about OSCR being able to increase transparency and accountability in charities, because ultimately it is a privilege to have charitable status, and it's really, really important that the public do have that confidence in our sector. I cannot argue with those aspirations. I think the one thing purely from a personal level that I would have liked to have seen and that we may see in the future is just some additional reforms that might help some in the sector themselves. Key thing to note, the charity test, the list of charitable purposes, the public benefit element, those remain unchanged, as do charity trustee duties. I'm hoping you can see these slides okay, because actually when I'm looking at them, they look teeny tiny, but I'm hoping they look okay for people at home. So the timetable, 3-stage process. Certain provisions came in April this year. We're sort of bang on trend, bang on date, because we're just a couple of days after a new raft of provisions came in on the 1st of October. And then the most challenging provisions in terms of OSCR having to build in systems at their end and charities having to get used to, okay, we're going to have to provide more information. They're coming in sort of the middle of next year is when that's anticipated. So the detail, the techie information now, information on charity trustees. So from next year, likely summer, there's going to be a list of charity trustees published on the OSCR website. So it'll just be their names. OSCR will have an internal database of all the sorts of stuff that we're used to sending to Companies House for charitable companies, but it's just the names that are going to appear. The current law, all you have to provide is details of the principal office. There is no list of charity trustees. And the aim is all about increasing transparency and accountability when OSCR is having to implement its inquiry and enforcement powers. Obviously, there is more admin for charities involved in this, but for those who are charitable companies, this is nothing new. You're used to submitting this sort of information to Companies House. I think it's going to be massively useful, especially when you're looking at things like potential mergers of charities, doing due diligence exercises for funders as well. So I cannot argue with this. I think it's a positive thing. There are exceptional circumstances when details of charity trustees can be kept off the register if it would jeopardise the safety or security of any person. I've had to do this in the past with a charitable company where it was being set up to help adults who had been victims of sexual abuse as children, and all those involved in the charity had themselves been abused. So we now also have, if you want to go on the OSCR website and look at it, I'm not sure how much information there will be at the moment, but a register of removed charity trustees just came in a couple of days ago. It's a publicly searchable database of those who've been removed from the management or control for misconduct. There was no prior equivalent of this. Again, I sometimes feel a bit like an A&E doctor. I've seen all the worst case scenarios in charities, and I've seen a lot of governance debacles, and some of these could have been resolved if, in appointing new charity trustees, if charities had been able to do a bit more due diligence and had been able to look up a register like this to see, oh, Gillian Harkness-McKinlay or Naomi Campbell, who's been in the news this week, have been removed and are not deemed appropriate. So I think this is a really, really great tool to support in the governance endeavours of charities moving forward. Accounts, yay! This will probably get the demographic here excited today. Accounts are going to be published on the OSCR website. This is going to come from summer next year. Again, for charitable companies, this is probably blink an eye and they're not water off a duck's back. They're used to doing this with Companies House. Currently, obviously, as you know, all charities have to prepare accounts, which have to be audited or independently examined. But there's actually only minimal information on finances appears on the Scottish Charity Register. So again, the aim is to increase transparency and accountability. I think it's going to be a really useful tool for all sorts of bodies, funders, for example, looking to fund SCIOs. They'll be able to see all of this information directly on the OSCR website, due diligence and mergers, all sorts of scenarios. So I think this will be really helpful with that aim of enhancing public confidence in charities. On removal of charities from the register for failing to submit accounts. So this came in April of this year. This is to help get rid of unresponsive charities. It's not like OSCR is going to come along with a scythe and remove their charitable status. They're going to, something's popping up on my screen. They will contact charities and actually explain to them, you failed to submit this. They will give them a time scale to then submit and to work with an independent examiner or an auditor. There is a grace period for charities to come back and say, okay, we're sorting this now. So previously they had to submit their accounts within 9 months of the financial year end, but now OSCR can take action if there's repeated failure to act. This will probably be of most concern to SCIOs, because obviously if you're removed from the register, you completely cease to exist as a legal entity, not so with charitable companies and other legal forms. But it's absolutely necessary for OSCR to be able to carry out its regulatory functions, and they will act proportionately as they are bound to do. Increased inquiry powers and powers of intervention. If there's anything that's controversial in the reforms, this is possibly the most controversial, and I'm saying that with a small c, controversial. OSCR now has the ability to investigate former charities and former charity trustees and issue directions to them not to take certain steps, for example, where it's related to the protection of assets which were once owned by a charity. I'm actually quite excited by this prospect, because I've seen so many previous examples of when the going gets tough, charity trustees just walking and leaving a hardy few to deal with situations, and they've seen it as a get out of jail card. So I think, and sometimes I've been asked in various situations, yeah, but what's the worst that can happen, or what's the worst that can happen to me? I think this will be really helpful to charity boards when they're trying to focus minds, that people, once they walk away, they can still come under the inquiry powers of OSCR and they can still be held to account. So I am actually seeing this as very much a positive. OSCR also now, from April this year, has the ability to issue positive directions to charities to do something or not to do something. It's mainly related to appointing additional trustees, removing a trustee who's been acting inappropriately, holding an AGM. But OSCR will only use these powers where there's been misconduct or where it's necessary really to protect the assets of the charity. I think people should take comfort from the fact that OSCR must only act in a way that's proportionate and taking action only where it's necessary. I cannot imagine OSCR going completely rogue and using this willy-nilly. It'll be a case of waiting to see how this pans out in practice, but my own personal experience of working with OSCR is that they have always acted in a manner which is extremely proportionate. So I don't think people should get unduly het up about this, and Martin can probably say something about this as well. So OSCR also has the ability to appoint interim trustees, helping charities out where they can't really function. This can be done on the request of charities themselves, but OSCR also now have the power to appoint charities either of their own accord or on the representation of third parties. And I could see that maybe being of use where you've got a senior management team who are at their wits' end because they don't have a functioning board anymore and they're trying to keep things going, but it's not within their gift to ensure appointment of further trustees. So this could be used where they're below quorum and OSCR can help with the appointment of interim trustees, usually only up to a kind of 12-month period. And again, requirement to act proportionately. Previously, OSCR was really kind of having to appoint acting trustees on request by a charity themselves. Disqualification, charity trustees. So there's new criteria have been introduced, just a kind of addition to the list of criteria for disqualification of charity trustees. None of these are particularly contentious. Some of them, I think you would look at them and think, well, I would have assumed that those would have been criteria already. The more interesting bit is that the disqualification provisions are extended to senior management roles. So if an individual is disqualified from acting as a charity trustee, they would similarly be disqualified from holding an office of employment with senior management functions within the charity. And that's really giving recognition to the fact that for those of us who sit on boards, we like to think the buck stops with us and that we are all important. But generally speaking, it is the senior management team who are in there every day, who are dealing with finances, and they have such a significant role. So I think that's a really, really important change from a governance perspective. Connection to Scotland. This might come as a surprise to some people, but previously, an organisation which wanted to represent itself as a charity in Scotland had to register with OSCR, but they didn't really have to have a particular link with Scotland, other than the case of SCIOs, who had to have their registered office in Scotland. From the 1st of April this year, OSCR was able to reject applications for charities which had no or only a negligible connection to Scotland. And now, as of a couple of days ago, they can actually review existing charities on the register. This might be of particular interest. I don't know if any of you work with American clients, but there are quite a lot of Americans who are looking to set up branches in Scotland. And sometimes when you speak to them initially, well, where are your charity trustees going to be? Are you going to have anyone based in Scotland? So I think this will be quite an interesting one going forward for some particular subsets of the sector. This is one I'm really excited about, the Register of Mergers. So from summer next year, there's going to be a creation of a publicly searchable register of charity mergers, and it's really to allow the transfer of legacies. So the vast majority of mergers I'm involved in, you're not setting up a new legal entity, you're taking one charity, it transfers all its assets and operations to another charity, and it's wound up. The recipient charity is going to have the ability to give OSCR notice of the merger following the transfer, and it will then go on this register. And it helps solve a problem which we've had around legacies and having to be reliant on how well the will was drafted in the mists of time to actually allow a transfer of bequests where the recipient charity has ceased to exist. And sometimes where it's not been drafted that well, or there's a concern things might not have been drafted that well, you've had a situation where the transferring charity has kept a kind of shell charity on the go to try and make sure any bequests and legacies come to them. So we're getting rid of all that hassle, both for OSCR and for the charity sector themselves, because this register of mergers will allow automatically these not very well drafted wills, and they will allow the bequests to transfer to the recipient charity in the merger context, notwithstanding the transferring charity has ceased to exist. I don't know how relevant this is to the people on the call today, but the 42-day notice period where OSCR consent is required, this used to be a bugbear for charities and more likely charity solicitors. So if you were applying for consent to change the name or the objects or wind up, you had to give 42 days notice to OSCR. Now, OSCR are very efficient and would typically come back within about a week, but you still had to wait out the 42 days before the charity could take action at an AGM. That's now gone. So you give notice as soon as you've got your consent from OSCR, happy days, off you go. So it cuts down on admin for the sector. Charity names. You're now going to be able to have two charities sort of appearing temporarily on the charity register with the same name in the context of, say, a change in legal form. So lots of unincorporated charities want to switch to becoming most often SCIOs, or in the past charitable companies, so they would get the benefit of limited liability. But it was a bit of a faff because you couldn't have two on the register with the same name at one time. So let's just pick Action for Children. If Action for Children had been unincorporated, they would have had to change it to Action for Children in Glasgow of the unincorp so that they could have the new entity with the Action for Children name. You're not going to have to do that anymore. So in this specific context, it will be possible to have two with the same name on the register. Again, simplifies matters greatly. OSCR now have powers vis-a-vis the known as names of charities. So if we take an example like Glasgow Life, which runs the Borough Collection, the Concert Hall, Kelvin Hall, all these establishments in Glasgow, its legal name is actually Culture and Sport Glasgow. if they had used a name other than Glasgow Life, something that was offensive or too similar to another charity, prior to April, OSCR would have no powers in relation to that, but now they do. So that makes sense, because a lot of charities are actually operating under these kind of business names rather than their legal names. So OSCR can say, sorry, you need to change that, and that's offensive or misleading or whatever else, in the same way that they can for legal names. Other changes, I don't know how relevant this will be to people, but OSCR has a reorganisation scheme for charities that don't have powers to amend their constitution. Most often trustees or UOD trustees, or where they've kind of their objects can no longer, or their charitable purposes can no longer be fulfilled. But there were certain bodies that couldn't benefit from that reorganisation scheme. So endowments held by charities constituted under Royal Charter, and there are quite a few in Scotland, St Andrews Ambulance Association, the various Royal Colleges of Physicians and whatnot. So now those can benefit from the OSCR reorganisation scheme, which makes things easier for those specific bodies. From April this year, and again, I think this is maybe something people sort of assumed was the case anyway, but if charities are removed from the register, so not SCIOs, but other legal forms, and they continue to exist, so a charitable company, they have to continue to apply those assets in furtherance of charitable purposes. And that was always the case, but additionally now for public benefit. So I'll take Glasgow Life again. It runs all sorts of gyms at council owned properties throughout Glasgow. If they lost their charitable status, heaven forbid, under the previous law, as long as they continue to use those assets for sports, that would have been fine. But if they were now to get rid of all the sort of public benefit and, you know, bringing in, say, people from disadvantaged backgrounds, or, you know, single mothers or whatever, and they just started to run a totally commercial gym operation, that's not something they would be able to do now. Statutory requirement to submit an annual return. Again, I think people probably assumed that was a thing. It's now, that is now a legal requirement. Gosh, I'm actually getting through this quite a bit faster than I thought. I was horrified I was going to drone on for ages. Wider review. This is something that the Scottish Government are still looking at, although their kind of programme for government maybe hasn't said as much about charities as people would have liked it to. I said at the beginning, I am very much in support of all of the reforms that are coming through currently. Most of them are just common sense. But there are certain other things that I would really, really love to see. One of these relates to the conversion of unincorporated associations. They are the type of charity that would be best helped from moving to a SCIO, as opposed from charitable companies converting to a SCIO. Charitable companies, yes, it is beneficial. There's less in the way of, you've got all this Companies Act legislation that applies to you. Now you could just have the focused charities legislation, but they have the benefit of limited liability. Unincorporated associations don't, but for them to convert, it's quite a costly and cumbersome process. And I think there's just been, from the legal sector and more generally, maybe at government level as well, a bit of, oh, this is a bit too hard to work out how we could do this. I think we could put our heads together and work something out in legislative reform that could make this a bit easier. Another thing that I would love to see, because you do see it causing me problems, is just some of the differences between SCIOs and charitable companies. I think because the SCIO legislation was drafted prior to some of the company law reforms, so SCIOs were kind of meant to take the best and most relevant bits of company law, but company law has kind of moved on a bit. So if we take, for example, changes to written resolution procedures, you don't need unanimous consent of all the members of a company to pass a written resolution, but you do for a SCIO. And it would actually be quite nice if we could rationalise that, because you see it cropping up as an issue. I saw it recently in a template that was being circulated for SCIOs, not something that was endorsed by OSCR, but a regulatory body was kind of putting it out there, and they had the position wrong. So I think it causes a wee bit of confusion. And I've kind of shoved some of that in there. So we'll wait and see what comes from the wider review. But there are groupings like the ICAS Charity Panel and the Law Society Charity Law Subcommittee who are kind of keeping an eye on this and pushing for some of this. Summary of the timetable of changes. Loads of them are now in force. So most of what I have gone through is in force. You can have a wee look at that yourselves. But the biggies, as I said earlier, the biggies in terms of there's going to be more admin for charities, more for charities to get used to. And I think OSCR's been really, really good on their social media channels at kind of drip feeding this information to get charities used to the fact you're going to have to get ready for submitting details of your charity trustee, telling us when those change, knowing that your accounts are going to be published in full along with your audit report or your independent examination report, and the charity merger, the record of charity mergers, which is probably more for OSCR to set up the infrastructure for that. That's me. I've seen various things popping up, but I've just closed them and brutally ignored them. So I don't know if the plan is for me to take questions now or maybe to pass on to Martin and then take questions at the end. Keith, what's your sense of this?
I think we'll just keep moving on. We'll go on to Martin's and then we'll wrap them all up at the end. I've got some comments in chat and we've got some hopefully questions coming through then as well.
Okay. So Martin, who is far more exciting to listen to than me, and he is the real deal with credibility. He is OSCR's Head of Regulation and Improvement. So I will hand over to Martin. You're on mute, Martin.
Excellent start, and after that superb build-up as well, I think I remember just about enough of being a new parent to think that sugary calpol is a good thing, but you know, I'll test that internally here. Yeah, so really, Gillian's done all the heavy lifting there with talking about the nuts and bolts of what's been brought in the new Act. What I want to talk about is, first of all, where are we with the practicalities of implementing all those nice new shiny things? What have we done? What are we planning to do? How does that involve people in the sector? The other thing, and this we'll probably speak to some of the direct experience of people on the call. We have, as many people will know, we've updated the annual return that we ask for from all charities, and I want to give a readout of what we're getting from that, both in terms of the data that we're getting from that, which is great, but also in terms of the feedback that we're getting and how we're responding to that. And last of all, I want to talk to you about OSCR's regulatory priorities. That's something that we launched last year. We've said we'll regularly review those, and I'm able to give you a bit of stop press there because we just talked about the annual review of those with the board, so I'll let you know where we're going with those. So plenty to do, so I will crack on there. Just talking about the 2023 Act, and really a couple of things that came up in what Gillian had to say, where I can maybe give you a little bit more information. So the things that have that were commenced and where we got our new powers back in April. One of the things there that's been the real focus of activity for us has been that power to take action where charities aren't submitting their accounts and where they've fallen behind with submitting their accounts. And that's been a real success for us. What had happened during the COVID period is a lot, especially smaller charities, but not exclusively, fallen behind with their accounts and really fallen out of engagement with us. And that was starting to be quite a factor in terms of the percentage of charities that were reporting to us. So we were very keen to get a hold of these powers and be able to try and re-engage with charities. And the powers have been really useful with that. We've removed, it'll be somewhere around 240 charities as of now. Those have gone through that process, gone through that grace period that Gillian was talking about, and we've removed them, I think in most cases because we're pretty sure they no longer exist, as opposed to being around and not engaging with us and breaching their duty to submit accounts. But the thing that we've been really pleased about is just how much of a tool this has been for being able to re-engage with charities. So we've had something around 160, 170 charities who have been failing to submit accounts, failing to get in touch with us for a number of years, have actually re-engaged and are starting to submit accounts and becoming visible on the register again. And I think that's a very good result from our point of view. I'll speak later on about what the focus of that bit of activity will be going forward, but we're very pleased with that. In terms of those inquiry powers that Gillian talked about, that the power of positive direction and the power to appoint trustees, I think what we're finding there is the awareness that we have those powers, and I think particularly with that power to look at the activities of former trustees, the awareness of that, or even when we make people aware that that's a factor, that is already helpful to us in our work, giving people a sense of there is no get out of jail card there, or that if a charity doesn't take action to sort out its governance, we have the ability to compel it to. I think those things are already having a pretty healthy effect. But what I wanted to talk about most of all was the stuff that's coming up and what we're doing around that, and particularly what we're doing with the sector, and I think particularly where we're looking to see how it sits with you, with the people that you work with. So, as Gillian said, will get at some point next year, and that's still a matter of discussion with Scottish Government. But at some point next year, we will get the duty to keep a schedule of charity trustees, which in modern terms basically means a database. That will be for internal use, and what we will really be, what we're excited about using that for is to allow us to maintain engagement with charities better. So we know with some of those charities that aren't submitting accounts, the problem is we've stopped being able to engage with the principal contact, and what having the trustee database allows us to do is other routes to try and maintain that engagement, or rebuild it where it's started to fail. It also allows us to have the appropriate and consistent communication channels where we are opening inquiries into charities. Sometimes it isn't appropriate to be going through the principal contact when you are needing to engage with charity trustees because there's been possible misconduct. So it gives us a faster in there. And really the way that we're designing the database is very much around taking in the minimum data points, the minimum pieces of information about any charity trustee that will allow us to do those jobs and no more. We think it's not right for us to be taking information we don't need. It's intrusive, and it also actually it poses a risk to us if the more information we have, the more personal information we have, the more of the risk there is to us as an organisation. So it will be a minimal set of information, name, address, email address, and a phone number and that's about being able to contact individuals, but also date of birth, so we can distinguish between individuals with the same or similar names. The way this will work, and we're currently in a procurement to get this system developed. The way this will work is something that looks and feels basically the same as the current OSCR Online system. It will be part of OSCR Online, the process for entering trustee details and for making updates to those. As Gillian said, charity trustee names only, it will be only the names, will be published as part of the charities register entry. You won't be able to do a search on trustee name. All you'll be able to do is a search by the charity, and it will come up with the trustee names along with the other information about the charity. That's very much based on how it's been implemented. It's been there for quite a while in England and Wales. That system seems to have bedded down quite comfortably, albeit they have a different mix of charities that they regulate, and they don't have a lot of the smaller charities. But we are talking a lot to charities, to umbrella bodies, about what the implications of that are, particularly talking around the power we have to exempt individuals from publication on the register where there's that threat to security of premises, and just who that will affect and how we should go about that. Linked to that, publishing charity accounts. So we'll have a new duty to make accounts available to the public, a duty to publish 5 years worth of accounts, and that'll be 5 years from the reporting period following commencement. What the requirements for what accounts need to be like won't change. The deadline for submission won't change. We won't redact accounts anymore, so we won't be redacting the personal information from those accounts. And I think that's probably the big message that we want to get out to the sector about this, that charities, trustees need to think about what personal information they are putting in there. There will be changes coming to the accounts regulations to make sure that trustees have the discretion to exclude personal information. For instance, where they've asked us to exclude someone's name from the register, they need to have the ability to exclude that name from the accounts. Likewise, we know that some smaller charities, for instance, will name beneficiaries in their trustees' annual report, and that's probably something they should be thinking about very seriously not doing if they're giving those accounts to us to publish. And we'll also continue to accept digital signatures on accounts. That's something we've been doing for a while. Gillian took you through the criteria for automatic disqualification of trustees. Those new things in orange are pretty unsurprising, and I think we'd all be pretty upset if some of the people in those categories were involved in running charities. So again, that is bringing us into line with the situation in England and Wales, and I think that'll be welcome. Under automatic disqualification of senior managers, that, as Gillian said, is the interesting bit. The way that this has been generally thought about is it means the equivalent of the chief executive and the chief finance officer. And where you have people with those job titles, that's relatively clear. Obviously, that's not the way it works in some smaller charities. And what we're doing is trying to explore that quite intensively at the moment with a lot of charities and umbrella bodies to see how those scenarios play out in smaller charities, and to make sure that the way we implement this reflects the reality out there. And obviously, this discussion is part of that, and very, very pleased to get any feedback you have on that. We do have the ability to waive disqualification in particular cases where someone applies for that to be done. And again, we want to know what people think we should take into account in making those waiver decisions. When should people in these categories be allowed to be charity trustees? What are the situations? What's the reason within a charity that should make us do that? So we're seeking views that's obviously there's a whole lot of technical implementation that's going very much on schedule, but the other big effort here is around talking to charities, engagement with the sector, making sure we understand how some of this will land and what how this will work in terms of the detail of how charities are and how they work. There's a few messages there that we're putting out through social media. What can charities do to prepare? And some of it is I think things that most charities will do anyway. Do you know who your trustees are? Do you have up-to-date information on them? Making sure the accounts are prepared in the right way. Identify any trustees or senior managers who might be impacted by the new situation around disqualification, and watch out for our guidance. Okay, so moving on to the new annual return. This came in for all charities with year ends on or after 30th November last year. The point of it is to give a system that's more responsive and hopefully gives more value both for us and for the charities that are submitting information to us, because what it does is gives a lot more responses to the information that charities are putting in. That's both in terms of guidance and pop-ups and messaging when, if particular information is put in, but also to send if there are particular characteristics, if there are particular things happening, then we will send automated guidance to charities where there are areas of concern. So we're looking and we will be looking much more closely at the data that comes out of the annual return, and I'll explain later on that this is having quite a big impact on our regulatory priorities. And the key ones there are charity trustees understanding their duties, and that thing about charities demonstrating to the public how they make a difference. So we looked at the submissions we'd received in July 2024. It had around 3,000 by then. They were sort of slightly skewed by the kind of charities that have those kind of year-end dates, but you'll see that that's relatively representative of the overall characteristics of what we get. The information that we got out there, that we weren't getting so well before. Most charities have 4 to 6 trustees, but unincorporated charities tend to have fewer, which can be a concern. We have some charities that have more than 50 trustees, and I think we knew a bit about those. A lot of those are in designated religious charities. 65% of charities have between 1 and 50 volunteers. There's 26% of charities have none. When we've issued guidance, there were 5 charities that stated they had fewer than 3 trustees, and that were SCIOs, and that's obviously not okay. We were in touch with them. 107 charities advising they don't have their own bank account. That tends to be a red flag in terms of other financial management issues. Lots of charities that hadn't reviewed their governing document in the last 3 years or have induction processes. So we've issued guidance about that, and some of the feedback on that's been quite interesting. 72 charities with no income or expenditure, 31 that have advised that aren't undertaking charitable activities, 30 with no expenditure but some income. And again, those are cases where we will probably follow up, because there start to be issues around providing public benefit there. Sometimes there'll be good reason for that, which is fine. Sometimes there won't. How's it been received? The feedback has generally been good. There's been a little bit of feedback about clarifying some of the questions, particularly around the question around the governing document, and I think some charities coming back and saying, "Oh, what is an induction process? What is it you think of as an induction process?" And had a little bit of discussion with some of those that have responded. And I think that what we need to do is give more guidance about what we consider to be contained within an induction process, because sometimes people are doing it, but they aren't recognizing that they're doing it. Inquiries about overseas activities, just how that is defined and how that sits there. I think that the data that we've had on that previously has been a bit erratic. And charities coming back and outlining where it might be appropriate for them not to have their own bank account, and that's been helpful as well. And the data we've got from that has been really key in terms of us updating and looking at our regulatory priorities. And we've just completed that process, and we're about to publish those. They will remain largely the same. The point of these is to allow us to meet our regulatory duties, to be proportionate, to be targeted in particular in the way that we go about our business, to make choices about where we take action and where we don't. And so what we want to do is set out publicly what our regulatory priorities are. That helps us make regulatory decisions, helps us shape conversations with the sector, to explain what we do, and to set a legitimate expectation for charities about how we'll deal with things. So the regulatory priorities that we have, we think will remain largely similar, with the exception of the final one. Big one here: charities that fail to engage with the regulator and demonstrate to the public how we make a difference. That includes charities that are failing to submit accounts, are failing to engage with us, but also those charities I was just talking about where they aren't doing anything, where there's no activity, or where the only activity is people taking fees from them, whether that's professional advisors, whether it's investment advisors. That's the only activity year on year, and we do still think that this is a top priority for us, and we will be slightly broadening our activity and being very proactive around that. Misuse of charitable assets for private gain. This is the top priority for the public. This is the one that underlies a lot of the concerns that we receive about charities. We know this is a key issue for lots of stakeholders, including funders and Parliament. It's relatively rare, but it's high impact when it happens, and we will be continuing to look at that. Charities and trustees' understanding of core governance matters, where that's flawed and incomplete, absolutely remains a priority. I think what's coming out of the annual return is a sort of low but persistent level of misunderstanding of some things that are quite nuts and bolts, but what they indicate is a lack of understanding of some of the core duties that trustees have, and what it means to act with care and diligence, what it means to understand what your charities do, and to take some of the key safeguards. So again, through the annual return process, but also in terms of proactive casework from that, we'll be cracking on with that. Poor relationships and conflict within charities. We are seeing more and more of this. It's getting more and more complex. I think it reflects charities being under financial pressure, all sorts of other pressures, and it becomes more and more difficult to deal with difficult decisions, to deal with difficult situations. This remains an issue for us. It remains a priority for us. I think we're looking to deal with those issues as far as we can through guidance and advice, but ultimately through using our inquiry powers where we have to. And the one little change, we were concentrating on charities' management of their reserves, but we think this needs to broaden. I think there's starting to be evidence, both from the annual return and from our casework, that charities' financial management, that the trustees' overall involvement in financial management and financial decision making is not always as well informed and active as it needs to be to make the best use of resources and to manage risk for their charities. So we will be broadening that slightly, but that continues to be a priority for us. I think that's all I've got to say. I'll leave it there and give us some time for questions.
Thanks, Martin, for all of that. And thanks, everyone. We've got some messages and questions coming in. Just before we move on to that live Q&A section of this, it would be great if you could leave us a rating for today's webinar. There'll be a poll appearing on your screens now or in the chat box at the top of your screen, and we really appreciate the feedback. So please take a few moments to respond. So just while you may be doing that, we'll pick up on a couple of the comments that have come through the chat, which I know Martin and Gillian have already provided some responses to. But Martin, maybe you just want to speak a little bit more widely on one of your responses. I think there was a comment about new board appointees signing a disclaimer as part of their onboarding that confirms they don't have any convictions for fraud, etc. And I think you'd responded about the declaration process there.
Yeah, so at the moment, when charities apply to become to be registered, we ask for a declaration from each prospective trustee. That's the only information that we currently get about trustees. Now, we will be expecting charities to let us know when they appoint new trustees, and we will do some background checking, some level of checking where we get that data. But the responsibility that is on charity trustees to do their due diligence around the people that they're appointing. And a lot of the conversations that we're having with the sector are around what that means and where there are, where there may be difficulties around that. That's something that the charity trustees should also be doing, but we know there are sometimes gaps in that and people find it difficult to do. We think there may be some difficult conversations for charities to have with, for instance, their existing senior managers, and we want to talk to trustees about what the implications of those are, because obviously that's talking about consequences for people's employment sometimes.
Yeah, of course, yeah. Yeah, so serious matters and serious considerations there. We also got a comment in separately about financial statements for charities, making reference to being prepared under the 2005 Act, and would it at some point be appropriate to start referring to the new 2023 Act in financial statements? I think, Gillian, you've already...
that off,
I was going to say, but just if you wanted to cover it more widely, yeah.
Yeah, the 2023 Act, if you read it on its own, it's not going to really make much sense. It's really just there to amend the 2005 Act. So references to the 2005 Act would be correct because they are to the 2005 Act as it has been amended by the 2023 Act.
Yeah, and the specific, and speaking as the auditor and the accountant, I suppose the specific duty on trustees to prepare accounts still sits solely in the 2005 Act, and so will continue to be applicable for that purpose, basically.
Do you want me to pick up on some of these other ones that I've typed answers to? Like, if anyone's looking at my answers, they'll just look, what is this? Someone's asked about the register of trustees and the approach to ex officio trustees, for example, like local authority appointments, and Martin will be smiling because he knows I love a charitable alio. I've set up quite a lot of them. You wouldn't be registering the council because they are not the trustee. They just have the right of appointment, but the trustees are not really there, in fact, not at all there in a representative capacity of the council. They are there to act solely in the best interests of that charity, albeit they've been appointed by the council. So it's just the names of the charity trustees, whether they're councillors or otherwise. Someone's also asked about the independent examiner's report that will be published, as will audit reports. I'm not going to touch them.
I was going to say, just reading there, I think the specific question around that was where maybe the independent examiner's report has been published with the independent examiner's address.
Now, I have just done one of
which
these,
might be their personal address as opposed to a firm address.
Yeah, I have just done
you shouldn't have confessed to that.
Yeah, I'm not trying to take anyone's work. I did it nicely for a club my kids are involved in. But yeah, gosh, I don't even remember. Did I put my address? I must have done, I suppose. But yeah, I think put your firm address. But if it has to be your personal address, could that be redacted, Martin, if it's personal addresses?
We won't be routinely redacting any information. So it is about, where there is a particular issue around jeopardizing security or safety, the accounts regulations will be amended to give the ability for trustees to withhold personal information in those kind of cases, but not routinely.
Yeah. Okay. What else was
Yeah.
there? Audit threshold. Who's covering that?
Yeah. So
Well,
there's
interested to see what Martin's saying.
yeah, there's a lot of discussion about audit thresholds. I mean, that's not part of the 2023 Act provisions. Obviously, it is something that Scottish Government asked about in their recent consultation on the wider review. And I think the responses have been published. I think there's quite a lot of responses. Not all of them mentioned audit thresholds. Some did. So Scottish Government will be having a look at that, and we'll certainly be discussing that with them. So I think watch this space with Scottish Government in terms of their response to that consultation.
I think the ICAS charity panel, or Christine can maybe weigh in here, or Keith, are definitely on top of this in terms of flying the flag and fighting the good fight.
Yes, so certainly not something that's in this part of the regulation, but part of the wider consultation going forward. So yeah, there's been a few other points coming in. Obviously, people have asked about the slides being shared after the meeting. We're confirming that yes, that will be these will be available there as well. So I think I've got one other. I think I've certainly got a question coming in through the Q&A as opposed to the chat. And that was one for yourself, Martin, on sharing any details of the process and timeline for updating the accounting regulations. We've probably just touched on that briefly.
Yes,
but
yeah, and there's obviously a read across between the accounting regulations and the commencement of the 2023 Act around publication of accounts. That read across between what information about individuals can be published. So again, there are discussions and considerations going on with Scottish Government, and that will have all the usual components. What's the ideal time to bring it out? We need to think about things like the submission deadlines and accounting dates and things, but also there are the usual things around parliamentary time for consideration of things like regulations and statutory instruments.
Yeah, okay. And I think we'll just maybe very briefly touch on a final, where a now deceased trustee was the primary donor and a legacy is delayed, leaving no immediate cash within months. What options are available? Maybe one for you, Gillian, or one to answer afterwards.
So like a primary donor to the charity?
A now deceased trustee was the primary donor and a legacy is delayed, leaving no immediate cash within months.
I mean, obviously there are kind of some quite serious issues there in terms of, I mean, again, it depends what kind of entity, as well as it also depends on what type of entity it is. So for example, if it's a company, and then you could potentially be getting yourself into wrongful trading territory if you're not able to trade. And then I wouldn't even try and touch on all the going concern stuff, which I know is the bag of accountants and auditors. OSCR in the past had, if we're looking specifically at the charity side, did have the notifiable events regime, which has changed a wee bit, and maybe Martin can speak more on that. So you're kind of looking at it from two sides. What should you be telling the regulator about where you are? And with the previous notifiable events regime, I think OSCR's approach was tell us about it so we know if there is a really serious issue that could tip the charity over. And as long as you've told us, and as long as you're showing us what can be done and what steps are being taken, and then from a kind of finance point of view, again, the charities are looking at, or the board is looking at, okay, well, is there a reasonable prospect that we can continue to operate? Certainly from a company law perspective, you're tipping into wrongful trading when there's no reasonable prospect of avoiding.
I think that's obviously a fairly complex and specific circumstance, and maybe one that we can maybe put in a wee answer to afterwards. I'm just very conscious of time here, and so I don't think it's anything that the Acts particularly deal with specifically in terms of the changes here. So, but as I say, we'll wrap up through the chat and the Q&A and pick up if there's anything that's not been answered, and just pull that together, and we'll issue that along with the recording of the webinar at icas.com/webinars. So just in wrapping up, if you remember that you can keep up to date with all the latest professional news, including information, guides and resources on icas.com. Quickly looking ahead, there's a range of webinars and events in the weeks ahead which you might wish to sign up for. On the 24th of October, ICAS's Head of Tax, Chris Campbell, will be providing a comprehensive overview of the tax issues you need to think about when advising partnership clients. And then on the 19th and 20th of November, there's the return, and the CA Summit is back for this year, which is a virtual event, award-winning way to connect with all the big ideas that are shaping the way you live and work. And then on the 8th of October, next week, an in-person must-attend conference marks the first opportunity to discover ICAS's fascinating research findings into the evolving needs and expectations of society, and learn how the profession can adapt to continue serving the public interest. So that's next week, and that's Beyond the Numbers. So links to sign up to all of these events are available at icas.com/events. It only remains for me to thank Gillian and Martin once again for their excellent presentations, and also for all of you for joining the webinar today. We hope it's been useful to you. So until next time, goodbye.